Mrs. A, it's over to you.
Okay. Good afternoon, everybody. Welcome to the LACIAC Live Debate, second edition of it. It's a great privilege and pleasure to welcome you all to Live Debates. And it's an important day for us at LACIAC because it means, or it underscores the continuance of what we had hoped to be a continuous series. And this is the second in the series. And we have very distinguished personalities here to give us very robust and great insight into a wonderful topic. The LACIAC Live Debates was born out of the need to create a platform where the arbitration community could objectively consider emerging trends and controversial, challenging issues in international arbitration. Our aim at LACIAC is to ensure the growth and development of sound arbitration practices, and also create the opportunity for the proper understanding of ongoing issues within the arbitration space, within our industry. And there was no better way, we thought, to do it than to have renowned practitioners, very seasoned personalities in the field, present opposing views on a topical issue, thereby creating room for intellectual discussions and enlightenment. Beyond contributing to the development of the community and those that came after, that come after us, we view this, among other things that we do, as LACIAC's little way of giving back to a community that has allowed us to thrive. I think it would be good to give kudos to the organizing committee and thank everyone who worked on realizing the objectives of the LACIAC Live debate, and everybody who has taken steps towards ensuring the success of this event. I'd like to thank particularly the debaters, Professor Naila Komer Obeid. Thank you very much, Professor. Professor Dakwa Konde. Thank you so much, both of you, for taking out considerable time to prepare for this debate and agreeing to debate. Thank you very much. And I'd also like to thank the moderator, Dr. Uchera Onwamebu. Thank you so much. And we look forward to having a wonderful time under your able leadership. I will not take much more of your time. I can't wait to watch the debate go live. So I hand over back to Dr. Uchera Onwamebu. He's an international attorney. I should introduce moderator, an international attorney with Arendt Fox LLP, Washington, D.C. And for over a decade, he was senior counsel at the World Bank's International Center for Settlement of Investment Disputes, ICSID. And prior to joining ICSID, he was a lawyer with the United Nations Compensation Commission in Geneva, Switzerland, having previously been in private law practice in London and in Nigeria. He is a barrister and solicitor of the Supreme Court of Nigeria and a solicitor of the Supreme Court of England and Wales. Dr. Onwamebu is licensed as a special legal consultant in the US District of Columbia. He's a member of the board of the Lagos Court of Arbitration and co-lead of the Europe, Middle East, Africa user group of the Silicon Valley Arbitration and Mediation Center. Dr. Onwamebu's current practice is focused on international investment arbitration. commercial disputes, and advisory services. So we will understand why he's our moderator today. He has served as arbitrator in disputes before ICSID, the ICC, Paris, the Permanent Court of Arbitration in The Hague, the Dubai International Arbitration Center, and the Court of Arbitration for Sport in Lausanne, Switzerland. He's on the panel of arbitrators of various institutions around the world, including ICSID, the WIPO Arbitration and Mediation Center, Geneva, Korean Commercial Arbitration Board, Seoul, and on the Users Council of the Singapore International Arbitration Center. With those sterling credentials, I hand over the mic. I yield to Dr. Uchera Nwamebu.
Wow, thank you so much, Mrs. Keridolu, SAN. This is a real pleasure and honor to be here. I want to thank LACIAC for this opportunity, and I also want to thank in particular, everybody who's been involved in putting this together. I would also want to welcome everybody who's participating from different parts of the world, different time zones. It's really an honor and pleasure to have you all here. As we're aware, there has been growing discontent around the world concerning the present mechanism for resolving investor-state disputes, which is primarily through arbitration, either ad hoc or institutional, before institutions such as ICSID. Now, the reasons for the discontent have varied, and there have been many proposals on how to address the concerns. Some countries have gone as far as pulling out of investment treaties or even amending their domestic laws in which their advance consent to such arbitration can be found. Some countries have withdrawn from the Washington Convention, and by so doing, signaling that they would no longer be submitting to the jurisdiction of the World Bank's ICSID. Now, among the many other options on the table is the idea of abandoning the investor-state dispute settlement mechanism as we know it today entirely, in favor of one that relies on the resolution of such disputes between states. That is, between the host state of the investment and the home state of the investor. And that brings me to the topic of today's debate, which is centered around the statement: investor-state dispute settlement is better for Africa and the Middle East than state-to-state dispute settlement. Now, this is a question that could be relevant for any region of the world. So why are we talking about Africa and Middle East today? Now, there are many reasons for that. First of all, LACIAC, incredible organization, has global reach and is able to organize events focused on different parts of the world at a time. Secondly, is the ever increasing volume of commercial activities between the Middle East and Africa, and this cannot be ignored. Thirdly, and perhaps more substantively, is the fact that many international instruments that deal with the protections afforded to foreign investors and their investments are framed along geographical lines. And we see instruments in the Middle East, such as the Arab Investment Agreement or the Arab League Investment Agreement. In Africa, there's the OHADA Treaty, the ECOWAS Supplementary Act on Investment, and most importantly, the ongoing negotiations around the investment chapter of the African Continental Free Trade Agreement. So that's why we are here talking about Africa and Middle East today, and one of these options on how to address the concerns surrounding the ISDS system as we know it today. Debating the subject are two very distinguished panelists whose credentials are so long that I cannot do them justice in the time available. You will see them on the screen. I can only say that we are extremely lucky to have them here today. And I thank LACIAC actually for the privilege of moderating their debate. Proposing the topic is Professor Naila Komer Obeid, who is founder of the Obeid Law Firm in Beirut, from where she joins us, and Professor Dabwa Konde of the University of Oxford will be opposing. He's joining us from Oxford. I'd love to hand over to them to get going, but first I wish to touch on 4 housekeeping points. The first point is that there is a poll which is open now and will be closing in another minute or two to give us a sense of how people feel about this subject. Now, when they start debating, each speaker will have 15 minutes for the first round of their presentation and another 5 minutes for the second round. There'll be a brief window between the first and second rounds for initial audience reactions. And after both rounds is when we open it up fully for questions from the audience. Questions can be asked by sending a message using the text function on Zoom, or you can simply raise your hand to catch my attention. The third point I'd like to make is that this event is being recorded and will be posted eventually on the LACIAC website. And by participating, we're all deemed to have provided our consent to that. Finally, I'd like to say that this event is purely an academic exercise. And so the views expressed by myself or our speakers and the participants will, especially those our speakers while in character, should not necessarily be assumed to be their views on the issues discussed. And so with these words, I'd like to invite Dr. Naila to present her arguments in favor of the proposition that ISDS is better for Africa and the Middle East than state-to-state settlement of such disputes. Dr. Naila.
Thank you very much, Uche, for your introduction. I would like firstly to thank LCAIC for organizing this event. And I'm very grateful for the organizer for choosing this really fascinating topic, very topical motion. And I am very also pleased to be joined by you, Uche, and by our colleague, Dapo. As you said, I will be defending today the motion that investor-state dispute settlement is more suitable for Africa and the Middle East than the state-to-state dispute settlement. To this end, I will first provide a brief historical overview of both SSDS, ISDS, then proceed to identify the limitation of SSDS in Africa and the Middle East. And finally, conclude with what I consider to be the obvious position, that is the significant advantages ISDS has over SSDS. While it is true that SSDS predates ISDS, in the 18th century, SSDS was the norm. In the early commercial treaties and some early investment treaties. Today, however, SSDS has become a less popular mechanism to solve investment disputes. ISDS mechanisms are widespread and predominantly found within BITs, multilateral investment treaties, investment contracts, or codified in domestic legislation. Since its introduction, ISDS has been embraced by investors as a fair, transparent, and efficient process for resolving investment disputes with states. In fact, quite tellingly, the number of recorded ISDS cases has skyrocketed, increasing from 51 in 2000 to be more than 980 cases by 2019. It is true that SSDS has attracted renewed attention as a result of the concerns associated with SSDS and a recent trend towards full-fledged investment chapters in free trade agreements and economic partnership agreements. However, I do not believe that SSDS is a mechanism adapted to the resolution of investment disputes in the context of Africa and the Middle East for the following reasons. First, SSDS, in my view, implies an over-politicization of investment disputes, which may result in negative consequences for both investors and states in the region. Concerning the risk of repoliticization of investment disputes, I will say that spreading the use of SSDS bears the real risk of consenting to a politicization of investment disputes. Even in cases where SSDS is provided for in the framework of a neutral forum aiming to keep disputes outside of the political realm, the infiltration of politics and diplomacy into investment disputes represents more than a mere likelihood with SSDS and threatens the neutral and efficient resolution of such disputes. This stands in stark contrast to the goal and raison d'etre of investment arbitration, which was to depoliticize investment disputes and offer investors an opportunity to defend their claims against the state interfering with their investments directly within the sole framework of investment law. Governments worldwide have adhered to the innovative approach when they started developing a web of bilateral and multilateral investment treaties. The European Commission, for instance, has identified the depoliticization of disputes as core reason of ISDS proceedings. The Common Market for Eastern and Southern Africa, COMESA, for example, provides for SSDS an illustration of the weakness of SSDS in Africa and the Middle East. I refer here to Middle East because some of the Middle Eastern countries like Egypt, Tunisia, adheres to this convention, to this treaty. A 2016 study found that while the COMESA Court of Justice has been established in order to promote compliance with regional agreements, this mechanism is underutilized in practice as member states are wary of bringing disputes against one another. Second, the implication of the investor's home state directly in a dispute with a host state may potentially contribute to an increase of diplomatic tensions between states. Third, SSDS mechanism further render investors dependent of their home state for the defense of their claims. One of the consequences of such dependency is that the fate of investors alleging abuses in a host country is bound up with the political situation in their home country. I would like to give here the example of Lebanon. How could Lebanese nationals investing abroad rely on their government for the protection of their interests, given the political and economic instability in their home country, combined with the corruption affecting Lebanese public institutions? Other countries in the Middle East and Africa are also destabilized by similar issues, be they on the financial, security, or political levels. Furthermore, one cannot ignore the reality that political and economic interest can play an important role in a state's decision to bring an action against another state. There are indeed important implications at stake in states advancing claims of private parties who have suffered losses against another state. Not only may it not be that beneficial for states to be using scarce public resources where the commercial parties would seem to be best placed to pursue their claims, but also the funding of the claim by the state in itself politicizes the case. These legitimate concerns are all the more accentuated in the Middle East and in Africa, where a number of countries are already constrained by investment climate weaknesses and regional political tensions. Enhancing the market's attractiveness for investors is particularly important in such sensitive regions that are often struggling to attract more and better FDIs. Furthermore, the COVID-19 pandemic is expected to negatively impact FDI's flows to Africa and the rest of the world. By way of example, the UNCTAD, in a survey in 2020, predicts that FDI flows to Africa will be reduced by 25 to 40% in 2020. The IMF also estimates that Africa's GDP will fall from 3.2% to 2.8% in 2020. Therefore, if the already challenging context is compounded by a possible risk of state-to-state claims, this can only shake the credibility and effectiveness of investment protections, would decrease, in my view, and as such may further negatively impact FDI in Africa and in the region. This brings me to the fourth reason that supports my motion. The SSDS procedure is fundamentally unattractive as far as investors are concerned, let alone its potential consequences on FDIs, which I have briefly touched on earlier. In the context of protecting the rights of foreign nationals outside their home jurisdiction, SSDS is marked by particularly long procedures as well as by red tape and bureaucratic entanglements. The inefficiencies and uncertainties that arise thus counter investment facilitation, hindering an efficient, predictable, and investment-friendly climate. It is true that more generally, a lack of speed is widely perceived by users as one of the downsides of international arbitration more generally. However, the resolution of a dispute between two states, one of which not being the true claimant in the proceeding, can only enhance such tendency, particularly the time an investor spends in obtaining the support of its home state before such state decides to bring a claim against the state hosting the investments.
5 minutes left.
Time is, sorry?
5 minutes left.
Okay, I will now, the fifth reason is the shortcoming about the enforcement of SSDS regarding the enforcement proceedings. Why ISDS remain the most sophisticated and adapted mechanism for the resolution of investment disputes in the Middle East and Africa, because ISDS efficiently protects investors against host state abuses. ISDS provisions actively mitigate political risk and ease access to the market in countries with high perceived risks. ISDS strengthens the rule of law, and this is the third advantage. ISDS provide the necessary means to enforce international treaty-based agreements in accordance with the rule of law. A big achievement of ISDS is to provide a relative equality in the international area among disputing parties who do not necessarily share the same domestic legal values and customs. Despite being an international remedy for breaches of international obligations, and as a result of its widespread use and success, ISDS can have important beneficial spillover effects on the rule of law in the host state. By providing a model, it may notably provide encouragement to citizens in host countries to be increasingly vocal in their demand for a law-based, transparent system. In addition of raising the standards of protection of international and national investors, ISDS helped break one of the last frontier of national monopoly, the domestic judicial system, resulting in an enhanced rule of law administration for all users. Finally, by avoiding the politicization of investment dispute, ISDS contributes to a wider use of legal norms in the international society. In conclusion, ISDS is a better mechanism for the resolution of investment dispute in the Middle East and Africa. As I have demonstrated, ISDS mechanisms are more efficient to resolve investment dispute. They also play a role in attracting FDI by mainly mitigating the political risks in jurisdictions that may be considered as high risk and in the promotion of the rule of law globally. SSDS in the context of Africa and the Middle East presents many weaknesses. In summary, resolving disputes through SSDS would translate into repoliticization of the process, unequal opportunities to investors depending on their state of nationality, as some states in Africa and in the Middle East may not be able to protect their interests of their investors due to their political situation, the creation of diplomatic tension, procedural and regularity shortcomings, which would burden both states and investor enforcement shortcomings. This concludes my favoring the motion.
Thank you so much, Neela. And that was right on point. You did it in just a few seconds, under 15 minutes. Thanks a lot. With this, I'd like to invite Datwa to present his opposing views. Datwa, over to you.
Thank you. Thank you very much. Good afternoon, everyone. It's a pleasure to have been asked to take part in this debate. My great thanks to the organizers. I have been asked to speak in opposition to the motion. Let me start by commending the arguments made by my friend and distinguished colleague, Professor Neela Komer-Obed. However, I will be arguing the opposite. I will be arguing that state-to-state dispute settlement is better for Africa and the Middle East. I can begin by noting that there has been much dissatisfaction regarding the investor-state dispute settlement system, and that this dissatisfaction has led to the United Nations Commission on International Trade Law, UNCITRAL, establishing a working group to consider reforms of the system. That working group has been meeting in Vienna and in New York for the last 3 years to consider whether that system can be reformed. The key question, though, is whether the investor-state dispute settlement system should be reformed, should it be transformed, or should it in fact be abolished? There are a number of options. We can keep ISDS, but reform it. We can keep ISDS, but promote state-to-state dispute settlement as an additional basis for settling investment disputes. Or thirdly, in fact, we can abolish ISDS and insist on state-to-state dispute settlement as the sole basis for settling investment disputes. And many states are in fact calling for that last option. Before explaining why state-to-state arbitration and state-to-state dispute settlement in general is preferable, let me outline some of the problems with the investor-state dispute settlement system. First, a real problem with ISDS is that the system encourages a proliferation of cases, with the result that there has been a lack of consistency among the hundreds, thousands even, of arbitral awards. This lack of consistency in turn leads to a lack of predictability, such that neither investors nor states have great confidence as to the probable results of their cases. This lack of predictability then increases the number and frequency of disputes in this area, and also increases the cost of settling these disputes and leads to further lack of consistency. And so we then have a vicious cycle. Indeed, the system cannot really be called a system at all. Each case is really an island on its own, without anything tying one case to another. A second problem with investor-state dispute settlement is that it distorts the incentives for the decision makers, the arbitrators, who decides these disputes. Arbitration in ISDS leads to real and perceived problems of arbitrator impartiality. Arbitrators, appointed of course by the parties, are often classified as either pro-investor or pro-state, and this then means that arbitrators often have the incentive to maintain their views in order to secure repeat appointments. A third problem with investor-state dispute settlement system is that it has been characterized by a terrible lack of diversity of arbitrators. The figures are actually quite stunning. Of the 372 individuals appointed to tribunals under ICSID, the International Center for the Settlement of Investment Disputes, between 1972 and 2011, so 372 individuals, only 37 of those 372 were appointed to around 50% of the cases. In short, 10% of arbitrators were appointed in 50% of the cases in a period of about 40 years. What's worse, almost half of these arbitrators are nationals of Western European countries, and a further 22% of them are citizens of North American countries. So nearly 3/4 of these arbitrators come from Western Europe and North America. Even worse, 93% of the arbitrators are men. Only 7% are women. And in fact, of those 7%, 2/3 in that 40-year period of the women appointments were just 2 women. So ISDS has led to a terrible lack of diversity of the decision makers, the arbitrators. The position in state-to-state dispute settlement, though, is radically different. We can contrast ISDS with the state-to-state dispute settlement system that operates under the dispute settlement system of the World Trade Organization. Though both of these areas of international law regulate economic relations, the dispute settlement systems are radically different. In fact, someone once wrote an article saying that ISDS arbitrators are from Mars and WTO organization panel members are from Venus. We haven't had any problems at all with diversity in the WTO system, where the panelists that hear the cases are appointed by states. Now, this lack of diversity affects the legitimacy of the ISDS system. And slight adjustments, which are being made, admittedly being made, to the methods of appointment, do not seem to be sufficient to cure these problems. A fourth problem with ISDS relates to the duration and the costs of proceedings, which are excessive. This is not merely the cost of individual cases, and those are high, but the costs that are inherent in a system where there can be parallel proceedings dealing essentially with the same issue. There's no mechanism of taking these issues together in a single case, no ability for interested parties to intervene. Let me give you an example. The multiple cases that were brought against Argentina, all arising out of the measures that Argentina took with regard to the financial crisis that it suffered in the 1990s. Each investor, each company brought its own case, even though many of these cases raised precisely the same issues. So duplication of costs, duplication and increase in duration. Naturally, developing countries are affected the most by the costs of arbitration. The high cost of ISDS, which for states, of course, are paid out of public funds, is difficult to justify for developing states whose financial resources are scarce. So responding to the several ISDS claims that a state might face poses a disproportionately heavy burden on the officials of smaller states and on the public purse in smaller developing countries. Related to this is the fact that for investors, though, on the other hand, who bring the cases, those costs are often borne by third-party funders who then benefit financially from the bringing of these cases. In the UNCITRAL working group that I mentioned earlier, Nigeria made the point that, and I quote, "Why should a total stranger who has suffered no injury be allowed to benefit from the injury caused to others? In our view," Nigeria said, "the danger of third-party funding is that the funders are not known, and it poses real challenges, including the possibility of encouraging unmeritorious claims, the possibility of discouraging settlement, and the risk that the funders may put their own interests ahead of the claimants," end quote. So if these are the problems of ISDS, it's not surprising that several initiatives have been taken to opt for state-to-state investment arbitration. Just to give some examples, the new NAFTA, which President Trump likes to tout, provides in its investment chapter that once it becomes fully operational, that investment chapter will only be enforceable as between Canada and the United States through state-to-state panels that are reminiscent of the WTO system. South Africa's Protection of Investment Act of 2015 provides for state-to-state arbitration after exhaustion of domestic legal remedies with the state's consent. Brazil has done something similar with its investment facilitation agreements, also providing for state-to-state arbitration only. The Southern African Development Community, SADC, in its Model Bilateral Investment Treaty, expresses a preference for state-to-state arbitration over ISDS, with the option of the state bringing a dispute on behalf of the investor. But in what ways is state-to-state dispute settlement better? In the time that I have left, let me give you some of the advantages. First, state-to-state dispute settlement shows greater respect for state sovereignty than ISDS, and potentially a more careful balancing of public policy considerations. How is that so? Well, investor-state jurisprudence has demonstrated that investors will cross boundaries to sue for compensation that arguably home states will not cross, especially with respect to challenging legitimate public policy measures. So we've seen challenges, for example, to environmental protection measures, health protection measures, measures to protect other important public policy domains which investors challenge, and home states would not cross those boundaries because they are states too, and they have those same policy challenges and those same policy concerns. So in a state-to-state dispute settlement system, it would have the positive effect of driving the interpretation of treaties, if you like, towards the center. states would be concerned about exposing themselves in future cases to making outlandish claims about nullifying measures that are taken to protect legitimate public policy concerns. Secondly, if we had state-to-state dispute settlement system, it is actually likely to end up overall reducing the overall costs for
5 minutes.
Thank you. Reducing the overall costs for developing countries. Consultations and negotiations may settle the dispute earlier. Governments would not pursue frivolous claims for reasons of costs and allocation of resources. And there will be the possibility of aggregating claims that are likely to go together. Think, for example, of the dispute settlement system that arose or that was established between Iran and the US after the Iranian Revolution, where both sides were able to bring claims on behalf of their nationals. And this led to an aggregation of claims that were very similar. And it led actually to genuine settlement of a number of these disputes and a number of these claims by states. As I've already indicated, concerns over the impartiality of arbitrators would not be as pertinent in state-to-state arbitrations. The incentive of reappointment would not arise in the same way. Arbitrators would not be classified as pro-investor or pro-state because they would all be appointed by states. And this would lead to a greater legitimacy of the system because there would be less of a concern that arbitrators are making their decisions because of incentives to reappointment. State-to-state dispute settlement would also address some of the inconsistencies and provide greater certainty and predictability to governments, to investors, and to others. States will tend to be more consistent in their arguments that they present, and they will adopt a more balanced approach that is in their common interest. Finally, having state-to-state dispute settlement would actually also allow for a greater range of defenses that may be argued for. For example, questions about whether states may take measures as countermeasures. These are issues that have arisen in ISDS, but which ISDS tribunals have not been able to address because the relevant states concerned are not parties before them. These measures could be addressed in a state-to-state dispute settlement system. So in conclusion, I would argue that state-to-state dispute settlement is better for Africa and the Middle East. It would bring greater consistency to this area. It would, in fact, reduce costs. It would allow for more balanced public policy decision-making, and it would give a greater legitimacy to the decision makers, the arbitrators who are involved in the decision-making. Thank you very much.
Thank you very much, Dabo, and thank you again, Naila. This has been most fascinating. In fact, this is a point in the program in which we're meant to go for a brief opening up for questions. But as happens when one receives very good briefs from both sides, it's yeah, I can't wait to hear what the other side has to say. You're thinking, what can they possibly say to this? And so I think we probably should go straight into the rebuttals at this stage. There's a question from Moses Omorebe, which has disappeared from the system, but it is there, amongst other questions from Mohammed Abdul Wahab, Shehu Mustafa, and so on. But we will come back to these questions because I would hate to interrupt the flow of things now. So, Naila, if you're ready, let's go straight into the rebuttals.
Yes, thank you very much, Dabo. I am well aware of the criticism formulated against the ISDS system. Some of these criticisms are, in my view, unsubstantiated. Other critics are legitimate. Some are presently being considered by a number of states and international bodies with a view to ensure a proper equilibrium between states and investors' rights, to ensure the fairness and perennity of. That being said, in view of the numerous advantages presented by ISDS, both the states and investors, I consider that the system shall survive. We should not throw the baby out of the bathwater. All relevant actors involved in investment law norm making in the Middle East and Africa should address the system's flaws with a view to improve the system rather than to eradicate or replace it. In response to the first criticism, one of the criticism that, in my view, are unsubstantiated is the fact that this system is not biased because, in fact, states are successful in the majority of the cases brought against them. Accordingly, the most recent UNCTAD statistic as known treaty-based ISDS cases out of 674 concluded cases, 246 were decided in favor of the state, 198 were decided in favor of the investor, 139 were settled, 77 were discontinued. In other words, investment tribunals have accepted to award damages to the claimants in only 29.3% of non-treaty-based cases to date. So this system is not biased for investor, to the contrary. Another criticism is the system is threatening the state's power to regulate in the public interest. The critics of ISDS arguing that investment protection regimes constitute an unjustifiable infringement of the sovereignty of the states. They say that it places unreasonable constraints on their ability to act in the public interest. Evidence shows that the vast majority of ISDS cases are not brought on the basis of legislative or regulatory acts. They are brought on the basis of the implementation of those acts by state public authorities. In addition, and as mentioned earlier, only a minority of claims are successful before investment tribunals. Investment tribunals have generally proved to be mindful of states' right to regulate. And I would like to refer to Philip Morris versus Uruguay and Philip Morris versus Australia, are prime examples of cases that provoked significant public outcry. I will also address some other critics that regarding the high cost burden on poorer countries. The question of the high costs incurred in ISDS proceedings is of particular relevance in the context of the Middle East and Africa, of course. Costs represent a heavy burden on poorer states that have to defend themselves against investor claims. In the context of the COVID-19 pandemic, such concerns have been expressed notably by the members of the African Union who have prompted the Council of Ministers of the African Union Organization to launch a process. The outcome of this had been adopted of a declaration, the risk of ISDS with respect to COVID-19 related measures. So in this respect, states were invited to explore all options available under international law to mitigate the risk associated within the number of claims. I think with the COVID-19, there will be also more and more tension, more problems, and with the financial situation, I don't think that state would be able to defend the true claimant within state-to-state dispute. Regarding the other criticism that you submitted, my colleague Dato, I am of the view that in state-to-state disputes, the process is very lengthy. And I refer to Barcelona traction versus Belgium versus Spain. After almost 8 years of court proceedings, the ICJ found that Belgium lacked just standing to exercise political diplomatic protection. Similarly, in dialogue case, Republic of Guinea versus Republic of Congo, it took more than 30 years after initiation of the proceedings for the ICJ to deliver its judgment on compensation. Furthermore, regarding the enforcement, I am not sure that state-to-state dispute, for the state-to-state dispute enforcement of the decision or the awards are easy. They are very difficult in comparison with ISDS, and here I will refer also to exit convention. There is no automatic recognition where we do not have any problem with enforcement. Also, many states made a reservation with respect to New York Convention. Many African and Middle Eastern states, they have made a commercial reservation, i.e. that the state applies the New York Convention only to disputes arising out of legal relationships considered as commercial under the national law of that state. And this is also not in favor of state-to-state dispute enforcement proceedings. Regarding arbitrator and the gender equality, I don't think that it is not the same issue in state-to-state disputes. And in all cases, in view of the cases that I already referred, 964 cases till 2020, I think that nothing could be perfect, but this, the method of settlement of dispute via ISDS confirmed that this is the most viable means for settlement of investment disputes. And I don't think that the system is not transparent because, as you know, exit award are published. We have jurisprudence. Regarding inconsistency, I don't think so because each case is different from the other regarding factual metrics of the case. However, of course, legal issues are tackled in maybe depending also on the factual matrix of the case, but we have recurrent same legal issue. This is that all of us noticed.
Thank you so much, Dr. Naylor. I think at this point, let's. I can't imagine what Dabo could possibly say to those arguments. So let's get him started. I should say there are lots of questions coming in, and they're all noted, and we'll try to get to them. But Dabo, you've got a tough job there. Let's hear what you have to say.
I do have a tough job, I will admit that. But I think I have some good answers to Naylor's very, very good point. So one of the main points that Naylor made in her opening statement was about the risk that SSDS would lead to an over-politicization of disputes. And in fact, this was one of the very reasons why ISDS was introduced in the first place. So the thinking was that if you took the home state of the investor out of the equation, and if the dispute was just between the investor and the host state, that would actually lead to fewer tensions between countries. Now, we have to remember the moment at which ISDS was initiated. We're going back now to the 1960s when these treaties were being drafted, to the 1970s when the ICSID Convention was first adopted. This was at a time when there were actually very few interstate cases. So the notion that states would litigate against each other, or that they would litigate on behalf of their nationals against each other, was not really that common. We're in a very different place today in 2020. Interstate litigation has become a fact of life in international relations and in international law. And the fact that one state brings a case against another state is in the main today, in the main, I don't say without exceptions, not remarkable and not regarded as an unfriendly act. In fact, let's think about, say, the dispute settlement system of the World Trade Organization, where we have seen hundreds of cases arising out of the regulation of trade, brought by one state against another state. And in the main, this is not seen as an unfriendly act. It's seen as a way of achieving greater predictability and greater clarity of the international law rules in that area. So my response would be that though at one point in time, interstate litigation may have been regarded as something that raises tension between states, that is no longer the case today. And states are very familiar now with taking up these cases. So this gets to the second point that Naila makes on the politicization point. The point that a state might find it difficult actually to get its state to intervene on its behalf. This is no doubt also a possibility. I wouldn't deny that. But actually today, states are very familiar with taking up these claims in the context of trade. So there's no reason why this cannot happen also in the context of investment. So that's a response to the politicization point. A second point that Naila made was about the risk of a decrease in FDI flows. So this is the argument that if we were to change the system of investment protection, particularly if we were to change the system whereby the investor gets to bring the case, then this might lead to a decrease in foreign direct investment. There are 2 points that I would make in response to that. The first is a general point that actually there are several studies that have shown that FDI flows, foreign direct investment flows, do not actually, in fact, tend to be linked to the amount, they do not tend to be linked to the presence or absence of bilateral investment treaties or other investment agreements. They tend to be linked more actually to the underlying economic realities and opportunities that exist. So that's my first point. The second point that I would make is that even if we were to adopt a system of SSDS, we would not be saying that there would be no system of protection. It would actually just be a different system of protection, which, for the reasons that I gave earlier, would actually be one that would have several advantages. So it's not a taking away of investment protections. Another point that Naila makes is about the duration of SSDS procedures. So, and she's just made this point again, pointing to several cases at the International Court of Justice where cases have taken a very long time to resolve. And she is right, of course. The 2 cases she mentions, the Barcelona Traction case, the Diallo case, took a very long time. But on the other hand, we've actually seen cases even at the International Court of Justice resolved in a very, very short period of time. Not investment cases now, but other cases. So for example, there's a case before the ICJ, the Avena case, which was a case between Mexico and the United States, where Mexico took up the claim of its nationals with regard to consular protection. This was a case that was decided in a matter of months before the International Court of Justice. Also, remember, quite apart from the fact that ICJ cases are now faster, the ICJ is not the only model. That's why I keep pointing to the WTO as well, where there are actually time limits for the settlement of these cases.
Thank you so much. Sorry, well, I just had you say finally, because the last point you made actually goes to the first question that we received, which perhaps you can touch on that in your finally, because it was addressed to you. This is from Moses Omorobe, who's asking, what are the dispute settlement mechanisms that will be used for state-to-state dispute settlement? And then after that, we will then jump into the rest of the questions, please.
Sure. Do you want me to take that question now?
As you conclude.
Okay, yes, I'll take that as I conclude. So the final point that I was just going to make was in response to the point that Nela makes about ISDS promoting the rule of law. So while it is true that ISDS does encourage investors to take cases and to resolve them on the basis of law, the downside, of course, of ISDS is that it arguably undermines the local judicial systems. It means that they don't actually have an opportunity to hear these cases. In a system of state-to-state dispute settlement, there would be, as always happens, first of all, a requirement of exhaustion of domestic remedies. And so it would actually give an opportunity for domestic judicial systems to be strengthened and to flourish before a case can be taken to the state-to-state dispute settlement. Now, let me come back to this question that was asked about what are the mechanisms of state-to-state dispute settlement, the question by Moses. So there would be a number of options. Option one could be having recourse to existing courts and tribunals. So for example, the International Court of Justice. We could always do that. Option two would be to have regard to state-to-state arbitration, and you could actually benefit from some of the advantages of arbitration. Option three would be to create a specialized court to deal with this, much like in the same way for the WTO, when the system was reformed in 1995, a new dispute settlement system was adopted. And then in addition to arbitral or judicial settlement, you could include actually as a precursor to that type of settlement, a requirement for conciliation, mediation, or negotiation as well. So thank you. Let me pause there.
Thank you so much. This has been most enlightening from the two of you. We've got so many questions, and we've got like less than 20 minutes to deal with them. But to kick off the questions, I want to use my moderator's prerogative to pose one or two questions that are just designed to further explain what you speakers have presented. And the first one really relates to the breadth of your positions. Do you consider that the views you've expressed today would be any different if they were if we were talking about a different part of the world? You know, if we are talking about disputes in Asia, for instance, or in the Americas, or would your positions be only relevant to Africa and the Middle East? And second question, which is somewhat related, is what other options do you see? Is there a third route that is viable? For instance, is there a place for political risk insurance to come in and address some of the issues that that you've touched on today? So I'll let you to very briefly, within a minute or two, address these questions by way of expanding what you've said, and then we'll go to the very specific questions that have been posed. You can go first, Dabo, since you're on the screen.
Thank you. Okay, so would my views be different if we were in another part of the world? I think no, actually, not really. I think, you know, the points that I have made are applicable to developing countries in general. So even if we were talking about Latin American countries or Asian countries, these points would still, I think, be valid. But I think the points are also valid even for developed countries too. And so whether we're talking about disputes between a developed country and a developing country, or even between developing countries, these points would be strong. Now, what other options do we see? I think the way I would respond to that is to say that actually it's not just about how disputes are kind of arbitrated or resolved by judicial mechanisms. We need a whole suite of ways of actually ensuring that the underlying rules of investment agreements are complied with. And I think in that regard, we would be agreed on that. We're agreed probably on the importance of having these underlying rules. It's just about what are the mechanisms for enforcing them. And I would be open to having these other mechanisms too, like the ones you mentioned.
Thank you. And Dr. Naila?
Yes, regarding this question, I am of the view that my arguments are true for all regions of the world. And I remain of the view that investment state dispute settlement is better not only for Africa and for the Middle East, but also for the whole region, for the whole region of the world. This is particularly true for the Middle East and Africa, where in foreign investment protection, where foreign investment promotion is very much needed nowadays because of the political situation, instability in the Middle East, and other also crises in Africa. So I do not change my view, and I fully support this motion, not only for the region that we mentioned today, but also for the whole world.
Thank you very much for that. And there are a number of questions that have come in dealing with the whole issue of where the interest of the state and the interest of the investor do not necessarily align or are not necessarily aligned. I think this goes to your position, Dabo. What happens in those instances where the interest of the state and the interest of the investor are not aligned? Who and what can the investor rely on to pursue its claim? And this is borrowing from questions posed by Mohammed Abdul Wahab and a couple of anonymous questions here, and from Shehu Mustafa as well. Yeah, so can you address that?
Yeah, so that's a good question. But what I would say is that we sort of need to interrogate why the interests of the state and the interest of the interest of the home state and the interest of the investor are not necessarily aligned. So I wouldn't say that actually we should give preference to the interests of the investor necessarily, because sometimes, and we've seen this actually in ISDS cases, investors make outlandish claims. And in fact, this is supported by the very statistic that Naila gave us, that the vast majority of ISDS claims are actually rejected. They are actually, the tribunals actually find that they are not well-founded. And so there's a valuable role to be played actually in having the host state sometimes play a moderating influence in ensuring that these outlandish claims don't come before tribunals in the first place. Because all that happens when they come before tribunals is that the respondent state has costs to bear. And this goes back to some of the points I was making, for example, about challenges to public policy regulatory measures, right? Where investors there's no reason as an investor why you shouldn't actually bring a claim that is challenging this public policy regulatory measure, because you have been harmed. But actually a state might have a sort of wider view of this, and it might actually then mean that fewer of those outlandish claims are brought. So not necessarily a bad thing is what I would say.
Now, a somewhat related question to the first one is from Victor Ojea, who's asking for your reaction as to where there is weak political will and power on the part of the state. And I think this would also require Nela's input. What happens to your argument in those instances where the state is either in disarray or is weak or cannot afford to either defend an investor state case or even to pursue a state-to-state case on behalf of its investor. Dabo?
Yeah, so, it's interesting because litigation by states is actually very often an instrument of the weak. It's actually an instrument of the underdog. And we see lots of state-to-state cases that are brought by states that are weak. You just look at the case list before the International Court of Justice at the moment. There's a case between Somalia and Kenya. Somalia, which has had several challenges in relation to controlling its territory, still able to bring a case. Many cases between weaker countries and more powerful countries. So it's true that you might have cases where the state is weak, but as I say, litigation between states is in many cases actually a great leveler. It's the instrument of the weak to try to hold to account the powerful.
Thank you. So, Nela, so wouldn't it be a more just way to proceed in cases where the state is not able to afford defending numerous investor-state disputes or proceedings?
Your question if there are some other means that state could use to defend or a weak state, for example, destabilized by political tension or financial crisis, how we would be able to defend the interest of an investor in front of a developed country or rich country. So they will be in unbalanced situation, in my view. Especially nowadays in developing countries, there will be more and more instability and there will be more and more unfairness because there will be a balanced situation. What are the other means that state could use in developing country litigation, for example? And I saw in many Middle Eastern countries, I was involved in some litigation between state and investor, and but they resorted to a mechanism, a mediation mechanism, whereby the mediator will have a power also to decide. It's very different from the mediation that we know, and it was related to infrastructure project. In which the mediation clause provides for a mediator to resolve technical issues arising from the execution of the project. And I was able to resolve these issues, but the power given to the mediator was totally different. And I had to decide and provide them my opinion with respect to these issues. This could be a viable mechanism, but now I don't think that states could defend the true claimant. I'm here referring to developing countries, especially in Africa and the Middle East, with the crisis, with geopolitical crisis, with the financial crisis, and even for developed countries with the COVID-19, I am not sure that the state will have enough money to disburse to defend the investor. And this is the weakness of the system. In all cases, we have only few cases regarding disputes between state to state, and we have many cases in ISDS.
Now we are running out of time, and there are so many questions, very interesting questions to get through. There are questions from Rukiat Ibrahim, from Mohammed Kebe, and Adeola Agunbiade. But there is one question that kind of runs through everything, which is the issue of corruption, which some may argue is a real factor in the African Middle East context. So, how would this issue of corruption play into the position that you've taken, and how would it affect what you've told us today? Dr. Nela, we'll go with you first, and then we'll go to Professor Dabo.
Of course, the issue of corruption will impact because having corrupted institution, this will take time for the state to implement means to defend their investor, and they will take position with the investors that they would like to support, depending on the investment project. And of course, in my view, this is one of the weakness of SSDS when you have corrupted institutions.
And Dabo?
I think what I would say is that there's another side to the corruption issue. The other side to the corruption issue being that ISDS has not really been able to deal with cases where an investor brings a claim, but actually underlying the investment and involved in the investment is some degree of corruption. And then the state wants to defend the measures that it has taken on the basis that actually the investor themselves have actually been the source of the corruption. Because ISDS is very one-sided, because only claims by the investor against the state can be heard in such a system, and the state is not able to bring a corresponding claim against the investor, in those kinds of cases, and there have been a number of them, the state is not finding it very easy, actually, to be able to raise those issues of corruption against the investor, right? Because remember, it's, when we say that state officials are corrupt, they are also corrupt in relation to individuals. So a system of state-to-state dispute settlement system where you have two states, actually, and there may then be the possibility of the state being able to bring counterclaims, this might actually make it easier for that system to deal with the corruption of the state by the investor. So there are two sides to this question.
Thank you so much. We really are running out of time, and so I would love to invite our speakers to step out of their assumed characters and give us any final words that they may have. And in so doing, there are so many questions to get through. Mohammed Abdul Wahab talks about the WTO example as to what could go wrong with the state-to-state option. And yeah, there are a number of questions out there. So if you can take a look, give us a minute or a minute and a half maximum on your final general views on this topic, not necessarily in the character that you've assumed for the day. That way, you go first.
Okay, thank you very much. I mean, this is probably going to be my final word, so I should take the opportunity to again commend my distinguished friend and colleague Naila for the brilliant arguments that she has made. I mean, my own view, in reality, speaking for myself, is actually not that we should abolish investor-state dispute settlement system for many of the reasons that she's given. But I do think that the system needs serious reform. And there are discussions that are underway for reforming that system. That, you know, some of the problems that I pointed out, I think, are real problems with the system, which means that we need to think about how we make it better. I actually do think also that there is a role for state-to-state dispute settlement system, for a state-to-state settlement alongside ISDS, because I think that we need to have a way to ensure that we don't have a situation whereby we have, you know, so many disputes that essentially raise the same issue, but there's no way of aggregating them. And sometimes SSDS might be a way of aggregating those issues and actually reduce costs in a way where you can solve those problems in one situation. Just to respond very quickly to a couple of the questions people asked. So Mohammed's question about the WTO, he's of course right that the WTO dispute settlement system is in crisis, and that suggests politicization. But it's also true that the ISDS system also has crisis. States are also pulling out of that system. So we can't totally actually avoid the politicization question, whichever of these methods we go for. So perhaps I should, you know, end there and let Naila give her own concluding remarks.
Thank you. Thank you,
And in
Dapo.
so doing, Naila, please also let us, if there are any aspects of Dapo's arguments that you actually do agree with.
Of course, that I agree that state-to-state dispute investment dispute system should remain in place, but it has to ensure that there will be no unbalanced situation between poor states and rich states in the world. And of course, we need also to think about the mechanism, how to put in place council, international council being able to defend investor by poor state country or developing state country, the resources. Otherwise, there will be an inequality of arm between two states, and at the detriment of the investor. I would like to conclude by quoting Voltaire. Voltaire once said, "Perfection is attained by slow degrees. It requires the hand of time." The ISDS system is a relatively young system in the history of investment law. It will perfect itself with time. I cannot stress enough that it remains the most sophisticated and most efficient mechanism to resolve investment disputes today. These are my concluding remarks, and its use shall be beneficial for the investment climate and for the promotion of the rule of law in the Middle East and in Africa.
Thank you so much, Naila, and thanks again, Dapo. And thank you very much to our participants. There's the second poll, which you'll find on your screen now, and we will invite you to please participate in that. And before I hand over to Mrs. Akeredolu, I would love to again thank the team at LACIAC for putting this together. I'd love to thank Tunde Fabolu, Mrs. Akeredolu, of course, and Fumi Yai and Titilope at Daytona. This has been a very well put together event, and the topic is fascinating. as long as borders are open for investments, there will always be disputes between governments and foreign investors. And so the question is how best to address them. Today, we've looked at one of the options. It's by no means the only option, and we're not saying that that it is. The discussion continues, and we hope to be hearing more on this from LACIAC. Again, thank you very much. And at this point, I'll hand over to LACIAC, Ms. Akeredolu.
Thank you very much. I'd like to thank our debaters today, Professor Naila Komar Obeid, who proposed the motion, and Professor Dapo Akonde, who posed the motion. And I'd also like to thank Dr. Uchora Wame, who moderated so skillfully the debate today. I'd like to thank all participants. At some point, I observed that we had about 100 participants. Thank you very much, everybody who participated. I'd like to think I speak for everybody. I came away better informed and very educated. If anybody encounters me in the next, going forward, I will argue and discuss the issues discussed today like a connoisseur. Thank you very much for giving me a shortcut education to all of this beautiful body of information regarding investor and state arbitration. Thank you very much. I'd like to thank my colleagues at LACIAC. Thank you very much. And the organizers of the events. A lot of people put in a lot of time to ensure the success of this debate. The hosts, and everybody in the back end. Thank you very much for taking time out and taking part. The debaters, wow, amazing, amazing. All of the time you must have put into preparing for this. Thank you so much. Please, I hope you will be available to LACIAC again. Rest assured that we shall be coming after you again to tap into your wealth of knowledge. This kind of source is the kind of source we must not let go of in LACIAC, and rest assured that we shall be knocking like Oliver Twist. We shall be coming back to tap more into your wealth of knowledge. Thank you very much.
Thank you.
Thank you. Thank you very much.
Thank you all.
Thank you all. Thank you. We greatly enjoyed the debate. Thank you, Dapo. Thank you, Uchi. Thank you, LCIAC. Thank you for organizing this fabulous event. Thank you.
And my thanks to everyone.
Thank you.